Hello, I'm Robert Sickels. I'm a very senior shareholder at the powerhouse law firm of Sommers Schwartz, and I'm here today with Tad Roumayah, who runs the employment law department here at Sommers Schwartz and has obtained scores of great outcomes for his clients. Today, we're going to talk about a pretty hot topic in employment law, hostile work environment and sexual assault. And it's been a hot topic for a number of years. And of course, the most notable example being the Harvey Weinstein debacle that's been in the news for many years now. So, Tad, tell us exactly what is a hostile work environment in the context of sexual assault.
Absolutely, Rob. So these are some of the more disturbing cases that we handle in our department, and they're really sometimes some of the most sad cases because truly what you're seeing here, and a lot of times, is what it says. It's a hostile work environment. An employee is going through a very difficult time where it's a constant barrage normally of unwelcome sexual comments, sexual advances, physical touching, verbal stories or jokes, innuendo. These are the types of things that, when you look at both federal and state law, Title VII of the Civil Rights Act of 1964, that's our federal law, and the Michigan Elliott Larson Civil Rights Act, that type of hostile work environment is prohibited under both of those statutes. Now, it's important to understand one or two maybe isolated comments over time probably are not going to create a hostile work environment that is actionable or protected or prohibited, I should say, under these laws. But when your employer, whether it's a coworker, a manager, even a customer or a client, when you are being placed in a situation as a woman or as a man, where you are being constantly hit with a barrage of comments, innuendo, touching, to the point where it interferes with the terms and conditions of your employment and you're unable to perform your job to the best of your ability, that's when it really becomes a hostile, ongoing work environment that is a violation of your rights to be free from an environment free from sexual harassment. And
So,
that's what really.
Ted, let me interrupt you here. You've been talking in kind of generalities here. Do you have some real world examples that you can give us of cases that you've handled involving hostile work environment and sexual assault?
Absolutely, Rob. And again, these are some of the more shocking fact patterns that we see in our department. One that comes to mind immediately is the fire chief at a fire station who was male, who was masturbating in his office every single day while his female subordinate sat right outside his office. Absolutely no shame, just leering at her and not hiding it, just showing her that he was masturbating.
Hard to
Um,
believe, but go
yeah,
ahead.
this type of stuff happens, Rob. I tell you what, I have many, many stories of these situations. But a situation like that obviously falls into the bucket of being a hostile work environment because that employee has a right to be free from sexual conduct, unwelcome sexual conduct in the workplace. And believe me, this was highly unwelcome. And this guy kept doing it. So we represented this employee and we were able to obtain for her a very substantial outcome in terms of monetary damages for what she had to endure. And this is a woman who complained repeatedly about this, and nothing ever changed. He kept doing it. And there's just some individuals who do some really disgusting things out there. And we're glad to be able to represent employees who are faced with these situations.
What
Um,
damages can be collected in a hostile work environment sexual assault case?
Um, that's a good question, Rob. There are several different types of remedies available under these statutes. One is if you lose your job as a result of a hostile work environment, you can pursue lost wages, lost benefits, a substantial bucket of damages in these cases, and rightfully so, is that of mental and emotional distress. oftentimes these individuals, whether it's a female, a male, they're put into these situations where there's a severely lopsided power dynamic. They're afraid to lose their job. They're constantly being approached and hit with a barrage of sexual comments, sexual jokes, sometimes even touching and physical assault. And they that really has some really devastating mental and emotional impacts. And a lot of people have to go to therapy because of that. They're on medications due to the behavior. They're afraid. They're in a very fearful situation, afraid to lose their job, afraid to lose their livelihood through no fault of their own. So that is a substantial piece of damages. We also can pursue attorney's fees. We can pursue costs of litigation. And in rare circumstances, we can pursue punitive damages against an employer, which is an additional set of damages that are there to punish an employer for especially egregious conduct.
So the example you gave us involved repetitive behavior over time. Can a one-off episode qualify as a hostile work environment case?
Good question, Rob. And these are thankfully rare instances, but some of the more egregious cases that I've worked on and that I've represented my clients who have suffered these situations are those where a client has been raped or sexually assaulted in the workplace. These are rare circumstances, but when they happen, that one instance of a rape or a sexual assault can be enough to create a hostile work environment for that employee. While other types of sex harassment may need to be more repetitive, for example, comments, light physical touching, things of that nature, you can still be protected if you have one instance of a very egregious act, such as a rape. I represented recently a young woman who found herself in that situation where she was raped at a work function. It wasn't even on the premises of her employer, but she was at a work function, a conference, and her manager drugged her and raped her at the hotel. I represented her, and we were able to obtain a substantial outcome in terms of monetary damages for that case. So it's important to understand that you may not people may not often think that one instance could be enough to create a hostile work environment and that it has to be a repetitive pattern. However, if the one instance is so egregious that it's a sexual assault, then that could still be enough.
So tell me how bad the conduct needs to be in order to be able to maintain a successful lawsuit against your employer.
Sure, Rob. So, unless it's something really egregious, like a rape or a sexual assault, oftentimes it's really got to be a pattern or a repetitive type of conduct. So, for example, if your supervisor is constantly approaching you, trying to ask for sexual favors, saying sexual things to you, trying to make sexual advances towards you, commenting about your body, the way you look, texting you lewd messages, um, comments, whether it's verbal in writing, a couple of those over time are probably not going to rise to the level of a hostile work environment, but numerous over and over where it's a pattern and a barrage of these things where it's interfering with your ability to do your job, that is the courts are going to look at that and they're going to find that that is a sex harassment rising to the level of a hostile work environment.
So, Tad, if I'm someone who has been enduring a hostile work environment or has experienced one of these horrific episodes that you've described, why should I come to you?
If you unfortunately find yourself in this horrible situation of enduring a hostile work environment that you're being sexually harassed, it's important to come to us so that we can explain to you your rights. We can look at the facts of your case. We can help you understand what you can do about it. This is some of the most isolating things that can happen to someone is they're caught in the crosshairs of their employer or a coworker or even a client of your employer where they are being constantly harassed based on their sex. and having physical advances, verbal advances, and it's really hard to talk to anyone about it. There's sometimes there's shame, there's a power dynamic that's at play that you really need to have someone in your corner to help you understand your rights and what you can do to make the employer stop what they're doing. And if they continue to do it without taking any action to stop it, then you need someone in your corner who's going to be able to fight the employer and get you the remedies that you deserve for what you went through.
So I assume in the employment law context, and whether we're talking about whistleblowers or hostile work environment cases, experience matters when selecting a lawyer. Is that right?
Absolutely, Rob. And you don't want to go to an attorney who moonlights in this area of law. You want to go to someone who's an expert like our firm, who understands the nuances, who understands what's protected under the law and what you can do about it. No sex harassment case is the same. Every sex harassment case, including hostile work environment sex harassment cases, are very unique. They have their own set of facts and circumstances, and the law is applied differently on each of them. So you want to go to someone who's going to be in your corner, who knows what they're doing, who knows how to advise you, and who knows how to pursue the court process and litigation to obtain for you the damages and the remedies that you deserve for what you've endured as a result of being a victim of sex harassment.
Tad, if I suspect or I believe in my bones that I'm the victim of a hostile work environment, what should I do preliminarily to protect myself and preserve a claim?
Well, Rob, other than contacting a competent attorney who can represent you and help guide you through this process of pursuing a sex harassment case, there are some other things that are best practices that I always tell clients to do. And the first and foremost of that is document, document, document.
Sure.
Make sure that you keep a timeline of everything that's happening.
Hmm.
Make sure that you hold on to those text messages if you're getting harassed in writing via text, via email. Hold on to all of that information, because all of that is going to be extremely important later on when you're trying to prove what your employer did to you. Because as soon as you lawyer up and as soon as you try to pursue your remedies, all of a sudden the employer has amnesia or they deny that they did anything wrong. So to try to escape liability. So it's up to us. We have the burden of proof to show that this actually was happening and that you tried to speak out against it and you were unable to make it stop. So that's why you had to come to an attorney. And so please my one takeaway for everyone that's watching this: if you're a victim of sex harassment or hostile work environment, make sure that you keep a timeline of events and make sure that you document everything and hold on to all of your paper trail of everything that's happening to you.
Well, Tad, I want to thank you for being here today and sharing all this very enlightening, informative information with us. And go forth and do good work as you have been doing for years. Thank you very much.
Will do, Rob. Thanks. I've enjoyed being here with you.